May it please the Court, Your Honors. My name is Darius Kandawala. I'm joined by Sabrina Haran on behalf of Scottsdale Insurance Company. I'd like to reserve 5 minutes for rebuttal, please.
Very good.
Thank you. Your Honors, this insurance coverage dispute filed by Bay Area Partners was filed in an effort to seek to expand, in Scottsdale's belief, the plain language under the policy. This policy was issued with an endorsement that was specifically designed to provide for an exclusion for regulatory claims, a broad form exclusion that precluded claims brought by or on behalf of the government, such as the DOJ investigation and the subsequent key TAM action that was filed against Bay Area Partners. There's an error in this endorsement. In the heading of the endorsement, there's a reference to management insured coverage section. That should have said management insured and company coverage section, because that's the coverage section under the policy. Under this policy, there's three coverage sections.
Management insurance and company coverage section does set out two categories of coverage, correct?
Correct, Your Honor.
One for the management insureds and one for the company.
That's correct, Your Honor.
So there is, at least on the face of the policy, there is a distinction that can be made. And so the question that I need to ask you is, was there any effort to seek reformation of the contract if you're conceding there was a mistake?
Your Honor, there wasn't, and the reason why is that from our perspective, there would be no need for reformation. That is, the language was what it was intended to be. It was intended to always be an endorsement that applied to both the management insureds and the company, and that this endorsement modified a coverage section and could only...
When it comes to contract interpretation, absent an ambiguity, do we get to questions of intent as opposed to what's the language of the document itself?
You would look at the language of the document itself, but you would do so in the context of the policy as a whole, and you would apply the plain meaning of that policy in a logical context. So that is, that plain language of the policy has to be reconciled with other terms of the policy. And so the opposite is true. Language can't be read in a way that would be illogical, or an ambiguity can't be read in a way where the opposite reading, the alternative reading here advanced by Bay Area Partners, is something that can't be reconciled logically with the rest of the policy. Your Honor, back to your point about reformation. Appellee makes a point about that the straw man argument that this was a mistake and we should have sought reformation. Well, when we look at the reformation cases are truly cases where a party had a different intent going into the writing of the policy, such as the case they rely upon, Yablon. Under that policy, a life insurance policy, it provided for a trigger of life insurance benefits which was different than what the parties intended. That policy could be reconciled the way it was read. It could be read and applied exactly the way that it was issued, but it was wrong. So the insurer sought to reform the policy. And the court said, no, you can't reform the policy. You issued it with this endorsement, and so you have to live with it. Here, that's not the case. This can't be reconciled with the rest of the policy. There is no separate management insured coverage section under the policy, Your Honors. There are three coverage sections under the policy. There's a management insured and company coverage section, a fiduciary liability coverage section, and an employment practices coverage section. And when we look at the endorsement, it modifies a full coverage section. It modifies definitions to a coverage section, exclusions to a coverage section, limits of liability of a coverage section. So how do we reconcile that if we're going to say it only modifies the management insured piece of it and forget about the company? Because all of that is subsumed within the coverage section. Going beyond that, they say, one of their arguments is, we didn't know going into this. We didn't know until we got the actual policy what this policy was going to provide. Because you gave us a draft endorsement that was borrowed from a different form of policy, a D&O policy. And it said, it had language that it was to be determined. Well, both before the time the policy was issued, they had their broker review this, and their broker specifically references this endorsement and refers to it as modifying the management insured and company coverage section. They knew it was going to modify that company coverage the insuring clause under that coverage section, just like it was going to modify the insuring clause applicable to the management insureds. Now, perhaps more importantly, after the policy was issued, that same broker, Robert Spofford, issues another memo to his client. He goes through all of the endorsements of the policy, all of the terms of the policies, and in bold letters says, here's the new terms of the policy. Under that, the second item is this healthcare endorsement. Again, he refers to it as management insureds and company coverage section, sublimit of liability, $100,000. He refers to it as modifying that coverage section. So they knew both before and after this policy was issued, it was modifying coverage applicable to the company.
So the exclusions section of the policy contemplates something different than what I think you just argued as far as the insurance coverage in the classes, because the first paragraph says exclusions applicable to all insuring clauses. So at least in theory, it could have just said exclusions to this policy.
Correct.
So it seems to recognize there are differing insuring clauses, correct?
Under the guts of the policy itself, that's correct, Your Honor.
And then the exclusion that is in the, well, first the endorsement says, this is modifying the insurance under the management insured's coverage. Again, it recognizes there are multiple types of coverage afforded under the policy. Then the exclusion itself says, Section C is amended to include the following. Now, it doesn't identify C1 or C2, so arguably it covers every exclusion, but for the fact that the opening says we're only modifying the management insured's coverage section. So the exclusions recognize there are multiple insurance clauses. The endorsement says we're only modifying, to paraphrase it, that those clauses dealing with management insureds. Why is that not a reasonable interpretation in the context of the policy as a whole?
Your Honor, there's no exclusion in this policy applicable to management insureds that's not applicable to the company. So the distinguishing characteristic there is that there are broader exclusions applicable to the company that are not applicable to the management insureds. Every other endorsement in this policy is applicable to the full coverage section. But when you get to certain exclusions, yes, the coverage available to the company is more limited than the coverage available to directors, officers, management insureds, and employees under the policy, because these kind of policies...
There's a specific exclusion to the company, which is exclusion number 2, which is applicable only to insuring clause A3.
And there are a number of exclusions under that, Your Honor. Yes.
And so you have exclusion 1 applicable to all, exclusion 2 applicable only to clause A3. So what explains to the trial court and to this court that, in fact, this endorsement, which says it's only as to the management insureds, really has to apply to paragraph C1 of the exclusions as opposed to C2, or create a C3, which is probably what should have been done?
Well, no, it absolutely shouldn't have been done. It would apply to either or both, but it applies to the exclusion sections before you even get to the subsections. That is, there's no subsection there under the policy that it could modify where there's an exclusion section that's only applicable to individual insureds. That doesn't exist. They would have to rewrite the policy, which is against Florida law, and if they think Georgia law applies, it's against Georgia law for an insured or anyone else to be able to rewrite a policy and create a whole new set of exclusions that's only applicable to individual insureds and not the company, to try and reconcile it with their reading of this endorsement, which truly comes back to just the omission of the 2 words "and company." And, Your Honor, the omission of those words, yes, it was a shortcut, and again, yes, it was an error, but it was consistent with the way the parties had been referring to this all along.
But the opposite argument, I think, is that the policy has specific definitions for management insureds, it has specific definitions for directors and officers, and so forth. And so you have an endorsement that refers to a specifically defined group.
You have an endorsement that refers to a coverage section, which is the management insured coverage section. If within that endorsement...
You now have what appears to be an exclusion to that management insured coverage section.
That's correct, which is broad in that it's...
The company.
Of course it's the company. It's
Well,
exclusions...
I understand that's your argument, but that's not the way... The policy recognizes on page 3, management insureds, it defines what they are. The policy also references the directors and officers. It acknowledges that the insured, or it not acknowledges, it states the insured means the company and the management insureds. So again, there's two categories, at least two categories that are described in the policy, and then the endorsement only refers to this endorsement modifies the insurance as to one group, which is the management insureds, and there's an exclusion within that management insureds document, endorsement, that arguably can be read as only an exclusion for the management insureds.
Your Honor, if this...
I don't see that that's that much of a stretch of an interpretation.
Well, Your Honor, it is a stretch of an interpretation. It's an unreasonable interpretation because there's nothing in that preamble to that exclusion that says that it only applies to management insureds. There's nothing in the preamble to the endorsement as a whole that says this applies to management insureds.
If that was... The endorsement as a whole says this is applying to the management insured coverage, or the management insured's coverage.
Coverage
and
section.
Within that, there is what is now a new exclusion.
But the coverage section, that's the important part. I agree with you if this said, right, as painful as it would be, if this said this applies only to management insureds, then you're right. Then we would be down a layer. We'd be within the insuring clauses within that coverage section. But we're not.
So the limiting language on the first page that says this endorsement modifies insurance provided under the following. And then it talks about the management insurance coverage section. But it says that it's modifying the insurance, and there's an exclusion that is also modifying what I think, at least their position is, the exclusion as to the management insureds.
Your Honor,
I guess the problem I'm having, honestly, counsel, the problem I'm having is your position is this is not an ambiguous contract. There was no effort to provide parole evidence to explain the ambiguity. I understand there was some discussion as far as what was intended, but ultimately the argument was there's not an ambiguity, in which case the parole evidence or the other evidence is irrelevant, right?
correct.
So here we are.
Your Honors, again, we would submit that the plain language of the policy needs to be read in the context of all other terms of the policy. That this modifies an entire coverage section. There's nothing with respect to the exclusions that says it modifies and only applies to coverage for management insureds. It adds an exclusion, and it adds it to the exclusion section of the policy. This is no different than all the cases throughout the country that we cite where there are errors in these policies. These are manuscript endorsements that are added to policies, and there are errors that happen. There's sometimes subsection errors. Courts look past that. They say that we're going to apply the kind of standard of looking at what a layperson of reasonable intelligence is going to be able to read this policy, look at it in context, and try and determine what was this supposed to mean. Here we do have evidence as to what it was supposed to mean. Everybody referred to this coverage section as being either MIC, Management Insured Coverage Section, or Management Insured and Company Coverage Section. So when the title on the endorsement got put on there, the shorthand version of Management Insured and Company...
It's not a shorthand version, it's sloppiness, right? I mean, is that a shorthand version if the intention was to apply to the management insureds and the company?
It was used by everybody. So the sloppiness that you referred to, MIC...
The other side didn't draft the agreement, your side did.
Correct, and it should have been done better. It should have been done better, but the point would be affecting the intent of the parties. That's what Florida courts do. That's what Georgia courts do. It's not to reform it as the insureds would like you to do and expand coverage under the policy. They purchased a policy that has an exclusion on it, but for a sublimit of liability that we paid. And now they're trying to pretend like the policy...
So that's a 15-minute mark, just so you know.
Thank you very much.
Very good, thank you.
May it please the court, my name is William Petros, and I'm here on behalf of Bay Area Partners Appellee. The healthcare endorsement that is the subject of this appeal was not revealed to appellee in its final form until after the policy was issued. The endorsement did not exist in a prior policy. The evidence below proved that the endorsement language during the application process was evolving. Appellant's own agent did not itself know what the final form of this particular endorsement would take. And BAP, Bay Area Partners, agreed to accept the endorsement as drafted. And when it was finally drafted, and when it was provided to appellee at the time that it was issued, the term management insured coverage section was not a term the appellee had ever seen before. And notwithstanding appellant's assertions to the contrary in the briefs that have been filed, that term was never seen by the appellee management insured coverage section before this policy was issued. One thing is certain when you read the policy and you read the endorsement is that in its final form, this endorsement does not exclude coverage to the company unambiguously. If one were to look at this and say, well, it's somewhat ambiguous, again, the ambiguities would be strictly construed against the insurer. Moreover, exclusionary provisions are even more strictly construed. What we have here is a mistake, an alleged mistake. Whether it was indeed a mistake is really unknown. But appellant says there was a mistake, either clerical or typographical. And if that is indeed true, that there was a mistake in the drafting of this policy, then there is a procedure in place to relieve that problem. And it is set forth in Georgia Code 23.34. A party may obtain equitable relief by, quote, proper pleading and sufficient evidence. Of course, in Georgia, a unilateral mistake of a scrivener will not warrant reformation. So one would require a mutual mistake. Unfortunately, in this case, for Scottsdale, they never pled an affirmative defense of mutual mistake. They never sought leave to the court to file a complaint to reform. They never asked for equitable relief in any case. It is interesting that in their affirmative defenses, it's not as if Scottsdale did not know about equitable defenses. They raised unclean hands, waiver, estoppel, latches, all of these equitable defenses that they did not pursue. But as we are here today, appellant rejects equitable relief. They maintain the endorsement should be enforced, I'm quoting here, quote, exactly as written on page 30 of the initial brief. And in the reply, they devote an entire section to the argument that Scottsdale is not seeking reformation of a mistake. And so very, very clearly, you have two choices in this case. You can either accept the language, not this court, but when reviewing this case, you can accept the language of the endorsement as it is drafted, which unambiguously does not involve the company, or you can ask for reformation if indeed you can prove that it was a mutual mistake.
Let me follow up on a question I asked the appellant. The endorsement section C, excuse me, says exclusions in caps and bolded is amended to include the following.
Correct.
And the policy itself on page 4 has a subsection C, exclusions.
Correct.
And exclusions that are contained within the policy are two categories. One, exclusions applicable to all insuring clauses, and then paragraph 2, exclusions applicable only to insuring clause A3.
Correct.
So because of the wording on the endorsement, why is it not reasonable to, reading everything as a whole, to say this modification is a broad form exclusion applicable to all insuring clauses?
Okay. Exclusion C in the endorsement does not specify which insuring clause it modifies. Because the body of the policy modifies particular insuring clauses, it would be incumbent upon the drafter of this agreement to indicate in this section of the endorsement which insuring clauses it is modifying. If you were to take exclusion C as it appears in the endorsement and attempt to place it into the body of the policy itself, you could not do it. You would not know whether it goes in paragraph 1, which applies to all insuring clauses, or you would not know whether it goes in paragraph 2, which applies only to insuring clause 3. As it's modified, it easily could have, what they could have done here was say, add a paragraph 3 and say that this exclusion applies only to insuring clause 1, which has nothing whatsoever to do with the company, but they didn't do that. And so as a result, it fails for indefiniteness. If Your Honor were to look, for example, at a amended version of this endorsement that they filed after the fact, you'll see how they corrected what they considered to be their error. They wrote, under that particular provision, exclusions, subsection 1 is amended to include the following. So what they did was, in their endorsement that they redrafted after the fact, they said, we're going to plug it into paragraph 1. But they easily could have created a paragraph 3 and had it apply only to insuring clause 1. And insuring clause 1 applies to management insureds, not to the company. So under Georgia law, that particular endorsement does not have a place to go and must fail on the basis of indefiniteness. And we cite two cases in support of that.
The trial court did not resolve the issue of whether Florida or Georgia law applies?
I'm sorry?
Did the trial court resolve the issue of whether Florida or Georgia law applies?
I don't know that the court ever, because in the order granting summary judgment, it didn't say.
But to the extent that if we determine that we are reading the words of the policy and understanding the words of the policy themselves, am I correct that the law in Georgia and Florida would be essentially the same?
They would be essentially the same. I think Georgia law, well, two areas where they wouldn't, and we haven't talked at all about the ill-gotten gains arguments that are made here, but in the first series of arguments being discussed here, Georgia law seems to be more particular about reformation. They do not allow unilateral reformation. In Florida, they do in the case of fraud. I don't know in Georgia, but they have a very specific code about how you go about reformation in Georgia. And so, again, I didn't study Florida law because the law of construction here is very clear that under lex loci contractus, this is a Georgia case, pure and simple. In the briefs you will see there is no argument that's made, valid argument that's made in opposition to that. So Georgia law absolutely applies. But you are correct, with respect to reformation, generally Florida and Georgia law would be similar.
Well, and also, though, in terms of interpreting contracts, ambiguities, whether there's an ambiguity and so forth, you all haven't researched?
No, it's identical. They're identical. Ambiguity, and then with the perspective of the exclusionary endorsement, that's an even higher standard. They're so for sure in that regard. Now, the question about, just going back to those two Georgia decisions, the Dawson and the Hamrick decisions, in Georgia, they have what's called the blue pencil method to give clarity to an insurance provision. But it marks but does not write. And the example that the Hamrick decision gave was in a competition clause, it referred to the Atlanta metro area restriction on competition. And it says the court ruled in that case that we don't know what the Atlanta metro area absolutely is, so therefore, by indefiniteness, it must fail. And that's the case also, Your Honor, with respect to the exclusion C within the body of the endorsement. Now, as to the insurable claim argument, this case, the facts of this case, are completely distinguishable from any case nationwide in which it is argued that the return of ill-gotten gains is not insurable. In this particular case, it's uncontroverted that there was not any type of knowing violation of a requirement known to be material to the government's payment decision. It's uncontroverted that the work was performed competently, that there was no allegation to the contrary. It's true that Bay Area obtained fees commensurate with the work they performed. There's no evidence that BAP received any money it did not earn. And moreover, there's no disgorgement in this case. The appellee contracted with the facilities and was paid by the facilities. Did not obtain anything from the government it was forced to return. And even if this case were to be characterized as restitution, under Georgia law there is no authority that reimbursement, even if it is the return of ill-gotten gains, is uninsurable. There are 3 federal district court decisions, all of which involve money that was arguably stolen. One was an overdraft, the other was a fraudulent transfer, and the other involved back pay. In all 3 of those decisions, the only ones in Georgia on this point, they all said there would be no new Georgia rule that they would find with respect to reimbursement for restitution. It's important to note that Georgia allows parties to insure against an award of punitive damages, the Fowler decision. They allow a reimbursement for willful and wanton misconduct, and even racially discriminatory policies. But when you get to the case in Nationwide, one thing you'll learn from looking at all of them, and we have looked at every single case, certainly every single case cited by appellant in its brief. One thing that you'll learn, because there's cases that go on both sides of this issue on the case of restitution. Cases that deny coverage, whether on the basis of the definition of a loss or on policy grounds, they reach the conclusion because, as the level 3 decision, the seminal case in this area says, because the settlement money was the return of stolen goods. Even as the level 3 decision said, a more polite term is used. None of the cases cited by appellant in this case involve anything remotely similar to the facts in this case. The Twin City Fire case, for example, was a judgment for civil theft that was trebled. The Philadelphia Indemnity case was a settlement of a grand theft in exchange for a null pros. C&L versus Twin City Fire, which we unfortunately mistakenly refer to as Houston, was artificially inflated stock. They're all the same. They're all the return of stolen goods. In this case, what you had was a technical violation in which a settlement was made essentially from the point of the appellee to buy peace. The modern majority rule in this case is that the question of whether you're dealing with ill-gotten gains is a question of contract. And we cite 2 cases that are directly on point here, the U.S. Bank versus Indian Harbor decision and the Gallup case. And in that case, you look to the actual policy. In this case, the policy has a specific provision that says that in the case of dishonestly or deliberately fraudulent or criminal act of the insured, there'll be no coverage unless there is a final judgment. Of course, there was no criminal act, there was no financial impropriety, there was no return of ill-gotten gains, there was nothing of the sort. And in this case, both the settlement with the government, which was intended to essentially buy peace because investigations of this type are very much bad for business, does not constitute in any form or fashion the return of ill-gotten gains. And for that reason, for those reasons, we would ask that the decision, the judgment of the trial court be affirmed. Thank you.
Thank you, counsel.
Thank you again, Your Honors. Just touching upon the endorsement briefly before moving on to this uninsurable loss issue. Your Honors, counsel in their brief and just now referenced a new endorsement that's an updated version of the healthcare organization endorsement, and it modifies the exclusion section. It has the correct title on the endorsement. What this is, and we have testimony from the trial court proceeding on this, that Scottsdale, as it realized the error in the endorsement, has in its database of these endorsements updated it to reflect the correct thing. But what it shows is that that was the correct thing. So what we have is, we've got the history of the interaction between the parties, their broker, their insurance expert, the insurance themselves who knew what the policy was supposed to cover, and we've got an endorsement that confirms what the policy was supposed to cover. and not cover. That is, an exclusion applicable to the individual insureds and the company, subject to this sublimit of liability, which, again, Scottsdale paid. And no one raised any issue with respect to this language or suggested the language was ambiguous or said we don't understand it and we don't know if there's coverage available to the company. In fact, when they were getting quotes for their policy, this sloppy language which you referred to, the quotes were that they were getting coverage under a management insured coverage section. And not once did Bay Area say, hey, what about us? Are we getting company coverage? No, because everybody knew they were getting company coverage. It was all understood the whole time. Similarly, with respect to this endorsement, it was understood the whole time that it subsumed the individual insureds and the company, because just like every other D&O policy issued in the country, the coverage available to the company is either commensurate with or lesser than the coverage available to the individual insureds. Now, briefly, with respect to the uninsurable loss issue, Your Honors, we dispute the state's law that should apply here. Counsel has identified a couple cases that suggest that where the insurer's broker, so our broker, where they are located, when they accept the insured's offer to purchase insurance, that state's law should control. Well, those cases, one is in the context of where the insured and insurer agree that state's law should apply. Two is a case where the court says it's a factually intensive inquiry. It says in that case that it will find it's where the broker was, but it goes through a litany of other factors that it looked at to say that that state in particular had a number of contacts to the matter. Here, Georgia has zero contacts to the matter other than the fact that our broker who accepted their offer happened to be in Georgia at the time. We've got a policy that was issued to insureds in Florida, insureds that are all in Florida. We have an underlying dispute that was initiated by the DOJ, the U.S. Attorney's Office in Florida. And we've got a policy that has Florida-specific provisions, even so much as a service of suit clause that requires service or allows for service to be served on the Commissioner of Insurance in Florida. Your Honors, with respect to the uninsurable loss issue itself, the court in Philadelphia versus Sable went through and distinguished specifically these couple of outlier cases that counsel relies on, the U.S. Bank case and the Gallup case, finding that before you even get to this exclusion for dishonesty or fraud, you first have to have a loss. And when you have restitutionary payments, which is what the FCA provides for, you don't have a loss. And contrary to what appellees want to suggest, those cases are not all in the context of theft or fraud or willful wrongdoing or criminal wrongdoing. CNL, an 11th Circuit case, was in the context of a strict liability statute, Section 11 of the Securities Act. You don't have to prove anything other than a misstatement was made in a prospectus. That's it. And yet, because the company gets a benefit that it then has to pay back in a settlement, that court found properly that that amount was restitutionary. Here, under the False Claims Act, the allegation is that Bay Area partners submitted directly or indirectly false claims to the government. And that's what the False Claims Act provides. One who submits the claims or causes claims to be submitted, there will be liability. And the unwinding of that, the restitutionary part, can't be covered. So here it either reflects fines or penalties or restitutionary relief. And either way, even in the settlement context, we followed the decisions where numerous Florida courts, including most recently Philadelphia versus Sable, have found that that is uninsurable. It's a matter of law.
Very good, counsel. That takes us to the end of the time.
Thank you.
We know both of you traveled somewhat long distances, Miami and Ohio, so welcome, and